At the end of the day, I'm going to find a basis to downward depart under the catch-all. So the question then is whether I should exercise my discretion in doing it. Because I do find that this is a somewhat unique and complex situation because of the situation that maybe the victim has RAD. It's not totally clear that he does. It's not totally clear that what he has wasn't caused specifically by how he was treated by his parents. But I do recognize that there's enough that it creates an issue where this is not your normal situation of child abuse where their children are put in a cage or a box and there's nothing that explains what was going on here. Ultimately, the state is requesting 15 years, and I think the defense is requesting 1 year based on the motion, followed by probation. And I do note that I can go all the way up to 40 years. So at the end of the day, as I said before, I am totally convinced that what I do will not please anyone here, but ultimately the buck stops with me and the responsibility ends with me and falls on my shoulders to issue a sentence that I think is appropriate to the circumstances. And I will say that it is not lost on the court that not only is the defendant here going to be the one to suffer the weight of the sentence that I impose, but the entire family has already suffered the trauma and the ramifications and consequences of the defendant's conduct. And on that issue, I do think that the defendant exercised and expressed his remorse at that. I just wish he'd have been a little more forceful in getting the point to me that he actually acknowledges that what he did was wrong, and I didn't get that. I still didn't get that because I have some sneaking feeling that if all things being equal, the defendant might say that he would do the same thing over again because he thought it was the right thing to do out of love at the time he did it, and that creates problems for me. I hope that I'm wrong on that, but at least that doubt has been allowed to remain in my head. So, all right, so enough said on this. I am going to exercise my discretion to downward depart here. I'm going to, but I will tell you that the downward departure is not even remotely close to what the victim has requested, nor the defense counsel requested. And at the end of the day, the sentence that I'm going to impose is going to be longer than what the guidelines provide. I'm going to downward depart from 75 months to 60 months, and followed by 5 years of probation, 2 years of the first 2 years of probation of which will be in CC2. During the term of probation, the defendant is not to have any contact initiated with any of the 3 older children. Those children will be free once they reach age of majority to have contact with the defendant if they so choose. In any event, even if the children so choose to have contact with the defendant, they will not be able to do so until the defendant has first completed the following conditions of probation. I'm going to require that the defendant undergo a 40-hour anger management class, which can be taken while he is in custody, that he undergo a 40-hour parenting course, and that he also undergo a mental health evaluation. With respect to the youngest child, given the nature of the appointment or the adoption there, I'm going to require any contact or visitation be supervised, but ultimately subject to any restrictions that the dependency court imposes, because obviously the dependency court, if they're still involved, then maybe they're not involved anymore. They don't have any jurisdiction anymore. So I'm going to leave it that there be no contact unless it's supervised with respect to the younger child. And the reason the court is allowing that is the circumstances that presently exist. The youngest child has been adopted by the wife's mother. And it's just not realistic in the court's view that where the adoption was permitted of the wife's mother, that any rational people looking at this situation would conclude that the parents are not going to have any contact with that child, or they should not have allowed the adoption to be by the wife's mother to begin with. So,
There's some confidential provisions that we're not privy to, but that's generally the expectation, is that there'll be substantially like that there won't be.
I am privy to them because I was present. I don't believe that's true, but I think that if the court could say that whatever is in, I just don't know if the easiest thing.
well, does why don't you approach on that one point, because I don't want to inadvertently disclose something that's privileged.